Hello, friends. Patrick McFarland here of the Liberty Weekly podcast, coming at you with episode 64. And the show notes for this may be found at libertyweekly.net/64, along with the video version, which will be embedded in that show notes page, or you can find it by navigating to youtube.com or bitshoot.com, preferably bitshoot.com/libertyweekly, and you'll find that in the feed. Today, I'm going to be talking about a Supreme Court ruling that was just handed down the other day. And as you can see on the screen here, the title says, Supreme Court Rules for Police Officer in Excessive Force Case. And this is a New York Times article by Adam Liptak. It will be in the show notes page as well, linked there. So let's just dive into it here. The Supreme Court on Monday ruled for, I'm quoting the article here, the Supreme Court on Monday ruled for an Arizona police officer who shot a woman outside her home in Tucson. The court's decision was unsigned and issued without full briefing and oral argument, an indication that the majority found the case to be easy. So we'll get to this, but I just wanted to address it right away. Let's see here. This is SCOTUS blog. And I was in my Second Amendment video that I did, which isn't on screen here, I said that there was a different site that I was using called Oyez, and I said that's the unofficial page. Well, this is the actual official blog, or the unofficial official blog for the Supreme Court. It has everything that the court is doing, and it has, a blog where they kind of talk about what's on the court's docket. But here is the page for the Kisela v. Hughes case, and you can see here that it was picked up, a petition for a writ, and here there's a brief by the respondent and the reply of the petitioner. So here's all the filings, is what I'm trying to say, and the court heard the case on these briefs and then issued a judgment without even having oral arguments or anything like that. And as this says, that's a sign that the court found the case to be easy, but that certainly is not the case, and there should have been oral arguments, but we'll get to that. So Justice Sotomayor and Ruth Bader Ginsburg, the two most liberal justices on the court, issued a scathing dissent from the decision of the majority, and it's not often that I find myself agreeing with Justices Sotomayor or Ruth Bader Ginsburg, but in this case, I think their opinion was astute, their dissent was astute, and we'll get to that too. But she said this decision is not just wrong on the law, it also sends an alarming signal to law enforcement officers and the public. She wrote, it tells officers that they can shoot first and think later, and it tells the public that palpably unreasonable conduct will go unpunished. So to get into the facts, and I'm going to be going through the judgment of the opinion, so maybe I'll just skip this part. But you can see the New York Times column. In dissent, Justice Sotomayor said that the majority's reasoning was perplexing. The majority did not decide whether Officer Kisela's actions violated the Constitution, but it did say that there was no clear precedent that would have alerted him that opening fire in what he said was an effort to protect Miss Chadwick amounted to unconstitutionally excessive force. So let's go right into the facts here. You can read that New York Times article. I'll link it in the show notes page. Well, before we get into the actual opinion, which we'll do, here's what the blogger, the Harvard graduate blogger on SCOTUS blog said about it. In Kisela v. Hughes, the justices overturned without briefing or oral argument the ruling of the U.S. Court of Appeals for the Ninth Circuit in favor of Amy Hughes, whom Police Corporal Andrew Kisela shot and wounded in 2010. So what happened is that if I'm remembering correctly, the district court, the federal district court for the Ninth Circuit ruled against Amy Hughes, the petitioner, who she is suing. She's the plaintiff seeking civil rights relief under a federal statute. So that's why this is a federal case and not a state case. But at the district level, she sued and lost. And then the appellate court for the Ninth Circuit, which is one of the most liberal circuit, found in favor of her. But then the police officer appealed to the Supreme Court, and the Supreme Court decided to pick up the case, and they overturned it without hearing it without hearing briefs or oral arguments. And oral argument is when the attorneys will go to the Supreme Court and basically for, 15 or 30 minutes, they try and make a case in front of all the justices, and the justices will grill them and ask them questions about the facts, the law, and, why their client should win. I've done this before. It's very intimidating. But it's also a chance, to make a good, passionate case for your client. And some may find it enjoyable. I appreciate it because you get to have a conversation with the justices and really flesh out what the case is about for your client. But there was none of that. There was no oral argument. And briefing, there would be briefings that would include, each side would make their legal arguments. These briefs can get long, maybe 20 pages or something, just citing all the cases and recounting the facts, why you should win. There was none of that in this case at the Supreme Court level. They dismissed it before then. And you can also get other briefs, amicus briefs from third parties, like the Cato Institute does a lot of amicus briefs, just concerned third parties that are not a party to the lawsuit but are concerned about the way that the law will be formed or shaped. So yeah, this is what the facts of the case. Hughes filed the lawsuit against Kisela, alleging that the shooting violated her federal civil rights. A federal district judge ruled for Kisela, but the Ninth Circuit reversed. Today, in an unsigned opinion, the Supreme Court reversed the Ninth Circuit's ruling. The opinion explained that even if Kisela had violated the Fourth Amendment by using deadly force against Hughes, which the ruling described as a proposition that is not at all evident, Kisela could not be sued because any rights that he might have violated were not clearly established, a key factor in whether government officials enjoy immunity from lawsuits. So this is all about qualified immunity, which is something that protects, it's the, where we delegate rights to policemen that we don't have ourselves. This is government actors being blatantly shielded from liability for things that we might, as private citizens, be liable for. But because they're part of the government, they get these extra legal rights that the rest of us don't have. So then she kind of talks about how the court chastised the Ninth Circuit, saying that the Supreme Court had repeatedly told courts, and the Ninth Circuit in particular, not to define clearly established law at a high level of generality. This is especially important in excessive force cases, the court continued, because otherwise police officers in the field will have trouble figuring out what they can or cannot do. Well, maybe they should be smarter, or they should have personal jeopardy riding on it. So, yeah, we'll get into that. Therefore, the court observed police officers, quote, cannot be said to have violated a clearly established right unless the right's contours were sufficiently definite that any reasonable official in the defendant's shoes would have understood that he was violating it. So the right has to be so apparent and so well known that any police officer, that police officers should know what they can and cannot do, clearly delineated, so when they react in life or death situations, they know what to do. And they don't hesitate, I suppose. They don't hesitate to shoot someone 4 times. But the court added that the Ninth Circuit failed to implement that standard in a correct way. Indeed, the court suggested, although the Ninth Circuit's opinion in this case indicated that a case arising out of the FBI standoff at Ruby Ridge in 1992, quote, clearly established that the shooting here was unconstitutional, the panel's reliance on the Ruby Ridge case does not pass the straight-face test, because a reasonable police officer could miss the connection between the situation confronting the sniper at Ruby Ridge, who, quote, shot a man in the back while the man was retreating to a cabin. I think here she's referring to when the FBI alphabet soup, I think it was the ATF or the FBI, shot a teenager in the back while he was retreating to a cabin, because that's what happened at Ruby Ridge. So anyways, so you can read the SCOTUS blog opinion, but let's get right into the opinion here. This is from the Supreme Court of the United States, Kisela v. Hughes. This is on the petition for a writ of cert to the United States Court of Appeals for the Ninth Circuit. So these are the facts as recounted by the majority opinion, the ones that struck down the lawsuit. So the police officer was in Tucson. He shot Respondent Amy Hughes. The officer who shot Amy Hughes and 2 other officers arrived on the scene after hearing a police radio report that a woman was engaging in erratic behavior with a knife. They had been there but a few minutes, perhaps just a minute, when Kisela fired, shooting the plaintiff or the respondent. That just means that Amy Hughes is the respondent. She's responding to Andrew Kisela's petition. So Andrew Kisela appealed, and Amy Hughes is the respondent, even though she's the plaintiff in the original matter. I hope that's clear. So Hughes, the respondent, was holding a large knife. So when Kisela fired his weapon, Amy Hughes was holding a large kitchen knife, had taken steps toward another woman standing nearby, and had refused to drop the knife after at least 2 commands to do so. But all this takes place in the span of 1 minute, and Amy Hughes was 6 feet away from her roommate, as we'll find out here. The question in this case is whether at the time of the shooting, Kisela's actions violated clearly established law. So the record, and so they say here, the record viewed in the light most favorable to Hughes, the non-moving party, she's the respondent, so viewed in the light most favorable to her. And that's very important because I think that there's a legal case, not just from a voluntarist perspective, but in this situation, there's a legal case as to why this should not have been dismissed, even within the lexicon of the Supreme Court. So they said the record viewed in the light most favorable to Hughes shows the following, that on May 2010, somebody in Hughes's neighborhood called 911 to report that a woman was hacking at a tree with a kitchen knife. So this is why you maybe shouldn't call the police on mentally ill individuals that you see in the neighborhood, because they'll come and shoot them. Kisela and another police officer, Alex Garcia, heard about the report over the radio in their patrol car. They responded. A few minutes later, they contacted with the 911 caller, who gave them a description of Amy Hughes, saying that she was acting erratically. Then another police officer shows up. Garcia spotted a woman, later identified as Sharon Chadwick, standing next to a car in the driveway of a nearby house. A chain link fence with a locked gate separated Chadwick from the officers. So you get the chain link fence, there's Chadwick, and then Hughes comes out from the house with the knife. And she fitted the description of the mentally ill woman with a knife. Hughes then walks towards Chadwick and stops no more than 6 feet away. So she's 6 feet away. That's the entire length of my body, plus minus a few inches. All 3 officers then drew their guns. At least twice, they told Hughes to drop the knife. Apparently, Hughes didn't hear them. But viewing the record in the light most favorable to Hughes, Chadwick said, "Take it easy," to both Hughes and the officers. So Chadwick, the one without the knife, the roommate of Hughes, is telling the officers and Amy Hughes to calm down. And Hughes appeared calm, but she did not acknowledge the officer's presence or drop the knife. That statement, Hughes appeared calm, is very important because there is no objective indication that Hughes was about to stab anyone. Yes, Hughes was holding a knife, but she was not brandishing it. She was not waving it around. She appeared calm. She wasn't threatening anyone per se. She didn't drop the knife, but she didn't raise it. So Hughes appeared calm, but she did not acknowledge the officer's presence or drop the knife. There we go. Drop the knife. The top bar of the chain link fence blocked Kisela's line of fire, so he dropped to the ground and shot Hughes 4 times through the fence. Then the officers jumped the fence, handcuffed Hughes, and called paramedics, who transported her to the hospital. She was treated there for non-life-threatening injuries. Less than a minute had transpired from the moment the officers saw Chadwick to the moment Kisela fired the shots. So I don't know why they couldn't have tased her. I'm not an advocate of tasing because I think it's torture and cruel and inhumane, and people die from tasing. But in this situation, if you were trying to employ non-lethal force, you could incapacitate her by tasing her. That's why you have tasers, right? That's why you insist on using them. So all 3 of the officers later said that at the time of the shooting, they subjectively believed Hughes to be a threat to Chadwick. Of course they did, because they want to cover their own ass. But after the shooting, the officers discovered that Chadwick and Hughes were roommates, and Hughes had a history of mental illness. So this whole altercation spanned between Hughes and Chadwick. Apparently it was somewhat normal from Chadwick's perspective. Chadwick, in an affidavit produced during discovery, Chadwick said that a few minutes before the shooting, her boyfriend had told her that Hughes was threatening to kill Chadwick's dog, named Bunny. Chadwick came home to find Hughes somewhat distressed, and Hughes was in the house holding Bunny in one hand and a kitchen knife in the other. Hughes asked Chadwick if she wanted her to use the knife on the dog. The officers knew none of this, though. Chadwick went outside to get a $20 bill from her car, which is when the officers first saw her. In her affidavit, Chadwick said that she did not feel endangered at any time. Based on her experience as Hughes' roommate, apparently this was normal behavior. Chadwick stated that Hughes occasionally has episodes in which she acts inappropriately, but it's only for attention. So this whole lawsuit came about that Hughes sued Kisela under the revised statute in 1979. It was a U.S. code for a civil rights violation, excessive force in violation of the Fourth Amendment. That's why this is a federal case that's being heard, because she's seeking relief under a federal statute. So the court says that the Court of Appeals first held that the record viewed in the light most favorable to Hughes, that's most important, was sufficient to demonstrate that Kisela violated her Fourth Amendment rights. The court, the appellate court, next the Ninth Circuit, the most liberal one, the court held that the violation was clearly established because, in its view, the constitutional violation was obvious, and because of circuit precedent that the court perceived to be analogous. So the Ninth Circuit was referring and relying on their own precedent that they had made to say that, yes, this Fourth Amendment right was clear. The police officers should have known that they were violating the right. It was clearly established, and that it was obvious. Kisela, and of course this court disagrees, but Kisela filed a petition for rehearing en banc. Let's see, that's not as important. Okay, so the seminal case when it comes to excessive use of force is Tennessee versus Garner. You learn this case in constitutional criminal procedure in law school. The court addressed the constitutionality in Tennessee v. Garner of the police using force that can be deadly. There, the court held that, quote, where the officer has probable cause to believe that the suspect poses a threat of serious physical harm, either to the officer or to others, it is not constitutionally unreasonable to prevent escape by using deadly force. And if I remember the facts of Tennessee v. Garner, it was police officers responded to a home invasion or something, and they saw Garner climbing over a fence, and the police officer shot Garner. That's what I think happened. So probable cause is a burden in law. Probable cause, there's a few different interpretations of exactly what probable cause means, but the general one, and the one I prefer to use, is more likely than not. So it would be a 51% chance. It's a really low burden. It's a 51% chance that Hughes posed a threat to Chadwick, if I'm remembering her name correctly. That's a low burden. So in the split second, police officers have, is it more likely or not that Amy Hughes poses a threat to her roommate? Well, I think that viewed in the light most favorable to Amy Hughes, the Supreme Court should have found for Amy Hughes, given her the benefit of the doubt, because you're viewing the evidence in the light most favorable to Amy Hughes. So I think that as a police officer, yes, Amy Hughes was holding a knife, but she was not brandishing it. She was 6 feet away from the other person. She didn't drop it. She wasn't responding to commands, but she appeared calm and collected, according to the own facts from the opinion here. So I think that it was wrong for the Supreme Court to dismiss this case outright, because just from a legal perspective, I'm not even talking from a voluntarist perspective, but from a legal perspective, I think there's significant doubt. If you're viewing the evidence in the light most favorable to Amy Hughes, there's a question as to whether probable cause existed for the officers to shoot. Because if you're viewing the facts in the light most favorable to Amy Hughes, I don't think it's more likely than not that she was going to stab her roommate, because the signs and tells were not there. At the very least, there should have been briefs or oral arguments for the court to fully analyze whether or not that was the case. This is a legal issue that I think there's merits to believe that Amy Hughes could win. And they just dismiss it outright without even hearing the oral arguments or the briefings. And I think maybe that was a strategic decision by the Supreme Court to not, there's maybe a political decision. We have enough on our docket already. If we take another police abuse case, it's going to cause an uproar. We're going to stoke racial tension. And that's the whole reason why the Supreme Court shouldn't exist, in my opinion, or one of the reasons why, because you are setting precedent that the entire country has to follow. All 230 plus million Americans have to follow this decision by this one court. And of course, you're going to get a lot of people that are mad about that uniform decision. And so if we, afforded more state sovereignty, the states could decide these issues for themselves, and you wouldn't have the whole country living under one precedent. But that's an aside. So the seminal case is Tennessee v. Garner. I would suggest everyone look at the opinion. I'll link it in the show notes page. If only for the recounting of the case law. In the IRAC, you have your issue, rule, analysis, conclusion. That's how you set up legal writing. But in the rule section, there's always a meaty explanation of the precedent that they're following. This is the rule section starting right here in one of the first cases on this general subject. And that's what you learn in your first year, is how to read cases like this. But that's an aside. In Graham v. Connor, which is another seminal police abuse case, the court held that the question whether an officer has used excessive force, quote, requires careful attention to the facts and circumstances of each particular case, which is why the Supreme Court should have heard oral arguments on this, including the severity of the crime at issue, whether the suspect poses an immediate threat to the safety of the officers or others, and whether he is actively resisting arrest or attempting to evade arrest by flight. The reasonableness of a particular use of force must be judged from the perspective of a reasonable police officer on the scene, rather than with the 20/20 vision of hindsight. Well, I mean, that's where you get police officers getting off, is because the legal burden is a jury. So when this comes to a jury, which it should come to a jury, and this has to do with criminal trials too involving police officers, the jury is instructed that they cannot judge the officers' actions based on their own perception of the officer's action. And this gets into jury nullification too, but the judge gives the jury instructions and says, you must follow the jury instructions, right? And the jury instructions say, you cannot judge this police officer's actions based on your own opinion of what is right and wrong, or your own subjective opinion on whether the officer's use was justified. You must judge it on the lens of a reasonable police officer, so the jury has to pretend that they're judging the police officer based on the standard of another police officer, or based on their training, instead of objectively what the jury thinks is right and wrong. And they must do it because the judge commands. You have the jury instructions, you must find it guilty. And, unless people are educated on their Magna Carta or constitutional right to judge the justice of the laws and the facts, and I did that. Jury nullification. Everyone check out my series on jury nullification. Lysander Spooner, libertyweekly.net/56. And you'll get that. Also the Magna Carta, libertyweekly.net/58. Definitely check those out. So yeah, that's the problem. But continuing with the case law from Graham v. Connor, the calculus of reasonableness must embody allowance for the fact that police officers are often forced to make split-second judgments in circumstances that are tense, uncertain, and rapidly evolving about the amount of force that is necessary in a particular situation. Well, make them liable, just like a private citizen, is what I say. Private security firms. But here, the court need not and does not decide whether Kinsella violated the Fourth Amendment when he used deadly force against Hughes. For even assuming a Fourth Amendment violation occurred, a proposition that is not at all evident on these facts, Kinsella was at least entitled to qualified immunity. Qualified immunity attaches when an official's conduct does not violate clearly established statutory or constitutional rights of which a reasonable person would have known. That's White v. Pauley. Because the focus is on whether the officer had fair notice that her conduct was unlawful, reasonableness is judged against the backdrop of the law at the time of the conduct. So this is all depending, again, on what they're saying is a police officer needs to know clear-cut, what violates the Fourth Amendment and what doesn't based on the law at the time, according to the law. So although this court's case law does not require a case directly on point for a right to be clearly established, existing precedent must have placed the statutory or constitutional question beyond debate. So a police officer can knowingly and clearly violate your Fourth Amendment rights, but if that right is not defined in the case law, then you are not protected. So why do cases come about in the first place? Because there was a controversy in the real world, and the court and someone sued, someone's rights were violated, and they were sued. So the problem with this that I'm just seeing, I'm kind of pontificating here off the cuff, but the problem with this is that I see it, is that your Fourth Amendment rights are not protected unless they've been violated in the past through a different circumstance, and the court found that there was a constitutional right and defined it clearly. So your rights don't exist unless they had been violated before and a court walked in and noticed the violation and ruled that it was a violation and clearly defined that violation. It just seems counterintuitive and just screwed up. Like, we really need a private security. We need to get rid of the police or get rid of the war on drugs, get rid of the impetus behind why they would violate people's rights, and expose them to prosecution that any private citizen would be held up to. And I think the solution for that is to replace police departments with private security firms in a bottom-up kind of agorist manner, which I've talked about before on the show. So I'm already at 27 minutes, so I didn't want this to be too long. So you get some of that, and basically they talk about qualified immunity. They go through the rules. Specificity is especially important in the Fourth Amendment context, where the court has recognized that it is sometimes difficult for an officer to determine how the relevant legal doctrine, here excessive force, will apply to the factual situation the officer confronts. We'll hire smarter officers. So it goes on, and I don't want to recount all of it, but at least you get the legal rules unambiguously from me. You can go through the reasoning and see how the court, manipulates the evidence to fit their decision, to justify their decision. But so here's the facts. I guess I should be more respectful, to the court. But there might be some reason as to why they found, legally speaking, that this wasn't protected. According to the case law, I respectfully submit my opinion that they should have at least heard oral arguments and had briefings on this, because viewing the evidence in the light most favorable to Ms. Hughes, I think that there's a question as to whether or not probable cause existed, and they should have explored that. So what I would do like I said, I'm not a big fan of Justices Ruth Bader Ginsburg and Sotomayor. However, you can get her version of the events and her argument as to why probable cause didn't exist. She says, if this account of Kisela's conduct sounds unreasonable, that's because it is. And yet the court today insulates that conduct from liability under the doctrine of qualified immunity, holding that Kisela violated, quote, no clearly established law. I disagree. Viewing the facts in the light most favorable to Hughes, like I said, as the court must at summary judgment, a jury could find that Kisela violated Hughes' clearly established Fourth Amendment rights by needlessly resorting to lethal force. I think she's very reasonable here. I think this is a very good point, and it's the one that I articulated before. In holding otherwise, the court misapprehends the facts and misapplies the law, effectively treating qualified immunity as an absolute shield. I therefore respectfully dissent. So this case arrives at our doorstep on summary judgment, so we must view the evidence in the light most favorable to Hughes, the non-movement with respect to the central facts of the case. So I already discussed what she's saying here, independently, might I add. Because it is a summary judgment motion, the evidence should be viewed in the light most favorable to Ms. Hughes. So I'll link everything here. I have a whole bunch of opinions and commentary, one from Cato, the guys at Cato. I'm a Mises guy, but they're doing some good work at Cato in terms of police abuse and against the war on drugs. Here's the Cato Institute podcast. It's 10 minutes long from an attorney who has been working in this for a while, although it wasn't, let's see if it's working now. It was not working earlier. I was a little frustrated because I wanted to listen to it before I did this. Let's see. Please work, Cato Institute. This is just another reason why Mises is better, but it's still not working. So here's another opinion from Cato at Liberty. I'll include this in the show notes page. Here's an NPR article. Not a fan of NPR. Fox News. So you can get all the angles here, is what I'm getting at. Here's an LA Times article about the same. Here's a local newspaper's take on it. They seem to be agreeing with Sotomayor. And so read Sotomayor's opinion, her dissenting opinion. It's 15 pages long, so I'm not going to recount it all. But I'm sure that she provides a reasonable defense for us here. So I hope that my commentary was enlightening. It went a little longer than I wanted it to, at about 31 minutes here. But just a few housekeeping things. Let's see. BitChute.com. So on Monday, I had a episode, America's War for the Greater Middle East, and I used a careless choice of words, and I said that reading about all of these horrible wars and terrible humanitarian crises that our government has caused, I described that as entertaining for me. That was a poor choice of words. A little bit insensitive. It's not entertaining, it's fascinating would be a better choice of words. So I redact that, and it is so redacted. Here's ways to support the show through Patreon. Become a patron of the show at patreon.com/Liberty Weekly. You can support legal analysis like this that I'd like to be providing more of. However, you can get access to all these patron only posts that I'm scrolling through here. Early access to my personal meme cache that has about 1,000 plus memes in it. You can also get access to the Rothbard repository, which is a indexed and searchable repository of Murray Rothbard lectures, searchable by topic, and you can find the timestamps that Daniel from Actual Anarchy put together, and that's a great service for us. Also, don't forget about that Amazon affiliate link. If you go to libertyweekly.net/Amazon, it will take you right to the Amazon page, and you can do your regular shopping there, and you will help support this show and allow me to buy books that will fuel content. So I think that's about it. Definitely our community on MeWe is growing. I'll include a link in the show notes page. You can go to libertyweekly.net/MeWe, that's MEWE, to join the Liberty Weekly community on MeWe. I'm really glad about it. I think there's a lot of good interaction happening between listeners of the show. And there's a group chat feature that I frequent. And so if you go on the group chat, you can chat with me about the show, tell me if it sucks, tell me what you think about it. Hopefully you like it and you enjoy my commentary. So join us on MeWe there. I'm seriously debating getting rid of Facebook because it sucks. And so let me know what you think about that if you have any strong opinions. I don't want to get rid of my presence on Facebook per se, but there it is. So thanks everyone for joining me for this episode. I hope that you have a better understanding now of qualified immunity and the legal standards that the courts use, and you have a deeper understanding of the topic. So thanks so much. We'll be back on Friday with another episode.